The second session is At-Home Injuries, Liability and Defences. Our panellists for this session include Mr. Zachary Frost, James Whitcop, Esquire, and the moderator, Mr. Richard Montalbo. Mr. Frost has been representing applicants and plaintiffs for nearly a decade and a half. He is a certified specialist in workers' compensation, practicing in Fremont with Raymond E. Frost at the Frost Law Office. He has repeatedly been recognized as a super lawyer rising star and is a frequent presenter at prior CAAA conventions. Joining Mr. Frost is Mr. James Whitcop. Mr. Whitcop is the named partner in the firm of Whitcop Law Group located in San Jose, California. He graduated cum laude from SUNY Buffalo in 1997 with a major in psychology and a minor in English. He was accepted to the Santa Clara University School of Law in 1997 as a Heaphy Law Scholarship recipient. In 1998, he studied abroad at the University of Hong Kong School of Law. During law school, Mr. Whitcop was selected for highly competitive internships with the Oakland Raiders and Temple Chambers in Hong Kong, China. Mr. Whitcop successfully completed during on-campus interviews and was selected for a paid clerkship during his second year of law school. He was an honors moot court competitor in his final year of law school. Rounding out this panel as moderator is Mr. Richard Montalbo. Mr. Montalbo holds degrees in business economics and computer science and received his law degree from the University of the Pacific McGeorge School of Law, where he is currently an adjunct professor. He is also the architect behind Current Issues Workers' Compensation Conferences and a frequent presenter at various legal conferences and symposiums throughout the state of California. Mr. Montalbo is also the app developer and designer of the CompCalc, the industry's only smart device workers' compensation rating and indemnity app. He is also the author and editor of the Work Comp Index, a topical guide to the law of California workers' compensation. Let's join our final session, which is underway.
I just want to throw this out to the cosmos out there. Mark Viknes is here, and Mark has assists with people attempting to secure ERC. If you don't know what ERC is, talk to Mark about it, but it's an obscene giveaway by our government to employers. I'm going to give you Mark's phone number here. This is Mark Viknes, 510-325-1866. This is not a tacit or otherwise endorsement of any services, or no, I'm kidding. Anyway, give Mark a call, and if you don't know about ERC, you probably should, especially if you're an employer. Okay, let's and Mark's right back here. Let's go ahead and start with the final panel. Here's what we want to do in this final panel. You know, I heard both of them speak at CAW, and I was impressed with their presentation. So I reached out originally to Zach Frost's father, and I said, hey, I'd like your son to help us out. Then I saw Zach at the CAW conference, and I said, you know, I'd like you to go ahead and speak. And he said, oh, you know, you'll have to talk to my people, but we'll see if we can't help you out. And so he agreed, and then he got a hold of Mr. Whitcop, who is a defense attorney, who spoke with him as well. And their presentation, I thought, was so apropos. It was right on point. I thought it was fair, it was balanced, and I liked the presentation so much, I wanted to adopt them both to speak at my conference. So we're fortunate to have them both. What I'm going to do, this is Injuries at Home. I'm going to give you a little AOE COE primer before they take over. I'm not going to take a lot of time on this because we have gotten into their time. So I just want to read this. This is one of my lecture handouts, law school lecture handouts for my students. As a general rule, an injury will be industrial as arising out of and within the course of employment where there is one, consensual employment relationship in that the activity or services were incident to employment. The primary factors for the court to consider is whether there is benefit conferred and control or right to control on the part of the employer. I want you to think about this. Benefit conferred, I don't care if you're talking about defenses or otherwise, it's all the analysis turns on benefit conferred and control or right to control. Think about the going and coming rule. Why is that generally outside the course and scope of employment? Because there's no benefit conferred. There are exceptions to this, factually, but there's no benefit conferred. They just have to get to the damn, place of employment, usual and customary commute, and there's no control or right to control. Now you have customary commute and that sort of thing as exceptions. Think about commercial travelers rule. Okay, that's an exception. That brings it within the course and scope. Now, why is that? Huge benefit conferred. Perhaps not as much control or right to control. Think about why do we have the defenses of horseplay? Well, there's no benefit conferred there, and arguably there's no control or right to control. So the Borelli case is a seminal decision in this area, and that articulates the test. Now, separate and apart from that, you've got independent contractor, and this is the Dynamex case, and what the factors that are involved are the following. Employee versus independent contractor, they use the ABC test now under Dynamex. That is A, that the worker is free from control and direction of the hiring entity in connection with the performance of the work, both under contract for performance or work in fact. In other words, the employer is not controlling that work. B, that the worker performs work that is outside the usual course of the hiring entity's business. In other words, I have a fruit stand and I want a contractor to come in and put a bathroom. I don't engage in installing bathrooms. I sell fruit. And then C, that the worker is customarily engaged in an independent established trade occupation or business of the same nature, they cannot be, of the same nature as the work performed. That's the ABC test. Now, that was codified in 2750.3. I want to read this to you as well. A person providing labor or services for remuneration shall be considered an employee rather than an independent contractor unless the hiring entity demonstrates that all of the following conditions are satisfied. This is the ABC test. A, the person is free from control, direction of the hiring entity in connection with the performance of the work. B, that the person performs work that is outside the usual course of the hiring entity's business, and C, that the person is customarily engaged in independent established trade occupation or business not of the same nature. Then this last year we passed Prop 22. Prop 22 was codified in the Business and Professions Code 7451. What happened here is the app employees, app drivers, wanted to maintain, I guess some did, some didn't, but they wanted to, there was a group that wanted to maintain their status as an independent contractor. So we had a proposition that was passed. And in this proposition, it provides the following. An app-based, this is Business and Professions Code 7451, an app-based driver is an independent contractor, not an employer agent, with respect to an app-based driver relationship with a network company if the following conditions are met. Number one, the network company does not unilaterally prescribe specific dates, times, minimum number of hours. It sounds like that's a lack of control. B, that the network company does not require an app-based driver to accept a specific rideshare service or delivery service request. No control. C, that the network company does not restrict the app-based driver from performing rideshare services or deliveries through other networks. Lack of control. D, that the network company does not restrict the app-based driver from working with any other lawful business or enterprise. Now, just last week, that was challenged, whether or not that was constitutionally a valid statute. And the Castellanos case came down, and they upheld that statute. So that's kind of an overview, and that's an update. So the app-based statute, Prop 22, was upheld just last week. That case just came down. Okay, with that as an overview, we're going to talk about in-home, at-home injuries, defenses, and potential liability. For the adjusters that are working at home, for the professionals that are working at home, I think that this is probably going to open up some eyes to the employers that do not want to require employees to come into the workplace and they want to get rid of their office to save money. They need to realize that, I think, comes with a cost with regard to the potential liability presented by at-home work injuries. So I'm going to turn it over to our guest, Zachary Frost. Zach is somebody who I met a lot of years ago. Once again, I guess this is an age problem for me. I know his father a lot more than I do him. He's an applicant-based attorney, and again, he spoke at CAW this last year, and I was impressed with his presentation. James Whitkop is a defense attorney in the Bay Area. He has his own office, a number of attorneys working with him. He has, I've seen him speak at a number of conferences, but I think this is really the first time that you and I have ever been involved in a presentation. So let's go ahead and listen to what they have to say. In your materials, you'll see that they've developed some slides, and they're going to be reviewing those with us as we go through today's presentation. I'll turn it over to you two.
Great. So Jim and I had a case together for a woman who was injured while working at home, and that's kind of what led us down this path of doing this seminar together. And one of the first things when obviously doing this seminar is, I wanted to ask is, how many people are actually really working at home in our labor force? And so what the U.S. Labor Board statistics show was that in around 2001, we had about 1% of our labor force working from home. And from 2001 to 2019, we saw a gradual increase and go from 1% to about 3%. And then in 2020, we had COVID. And COVID changed everything. And by May of 2020, we had somewhere between 35 to 40% of the workforce working from home. And we thought, okay, this is going to be a new trend in workers' comp. We're going to have a majority of the workforce working at home. We're going to have this whole new kind of Pandora's box of at-home injuries, and where's all this headed? And what we found is May 2021, 1 year later, we were actually down to only 16% of people working at home. And as we sit here now, the stats show that it's really only somewhere between 7 to 9%. So it's more than pre-COVID, but it's definitely down from the peak of COVID. And so the question, and where we're going to go with all this is, okay, now that people are working at home, how does this affect workers' compensation coverage? And that's where we're headed. So I'm going to let Jim start.
Okay. So the Tidwell decision, we'll get into a little bit more. It was an interesting case. It was the first time that I was ever confronted with a claim for an injury sustained while the person was at home. And at that time when that case came in, I looked at it and I said, okay, give me some information regarding the case. And it turns out that she was allowed to work from home. So my original instinct was, okay, if you let her work from home, work's probably home is work, and anything that you would do at work is probably going to be compensable in terms of a work injury if you're doing it at home. And so the more I got into it, my initial instinct was, okay, this is going to be, it was a fall in a bathroom, and she fractured her femur. And I said, okay, this is personal comfort. It sounds like it's going to be compensable. So at that point, what I wanted to do is I wanted to get into the facts of the case a little bit deeper and figure out how I could put on a good faith defense for my client. And I'll get into the facts behind the case a little bit more here in a second. So after COVID, the workplace has been expanded, as Zach just talked about. Most people were working from a fixed location before, and now you see people working. It could be at a Starbucks with a laptop, it could be at an airport, it could be at a bar. I see that all the time. And they're probably supposed to be working from home. I tell my attorneys that work from home means I want you at home, right? I don't want you working somewhere else. So work has been expanded. And how does that affect our community? So when this case came in, I saw it as an opportunity to have a seminal case and litigate something that was a case of first impression. At that time, a lot of my competitors were already downsizing in terms of their footprint and to cut down on costs. So a lot of my competitors already were going to a partial hybrid remote workforce. And I said, okay, this is probably going to be the future with cloud-based technology, what have you. So I saw it as an opportunity to take on a case before. I never anticipated COVID, of course, but to get in early and to get a decision out there on when home-based injuries are considered work injuries. So this is pretty much an AOE COE presentation. AOE COE is not very well understood, I think, by a lot of people. So AOE just means arising out of employment. We know that. Well, what does that mean? Well, you can have something happen at work that doesn't necessarily arise out of work. You could have a heart attack. You could have a stroke. Even though the person has that heart attack or has that stroke at work, if it's an underlying condition and there was no contributing factor from work, it doesn't arise out of employment. So that's the difference between arising out of employment and course of employment. Course of employment just means that you're doing what you're supposed to be doing. You're providing, as Rich said, service and benefit to the employer. So an example of something where you're not doing service and benefit, like Rich said, horseplay. Okay, horseplay confers no benefit. So that's the difference between arising out of and course of employment. And we're going to be talking about denied cases as opposed to affirmative defenses today. And anyone want to take on the difference between a denial and affirmative defense? Any brave attorneys out there want to tell me what they think the difference is? No? Okay, so a denial just means that is not a work injury. Okay, that is a denial. And in workers' compensation, we deny cases whether it's a true denial or whether it's an affirmative defense. We issue what's called a denial. But an affirmative defense means the claim would otherwise be compensable, but for this affirmative defense. Intoxication, right? That's an affirmative defense. So yes, there was a work injury, but it is barred. So there's a difference between denial and affirmative defense, and I encourage everyone to make sure that you understand the difference. We're going to be talking about just denials today, which is this activity is not work-related, okay? It's not considered a work injury. So pre-Tidwell is the case that we're going to get into, the case that Zach was the applicant attorney and I was the defense attorney. There is a line of authority that talks about home-based injuries before Tidwell. So Tidwell wasn't the first case to talk about an injury that happened at home, but it was the first time that I can find in California that any case discussed personal comfort matters at home. Okay, so in that case, it was in that situation, it was a case of first impression. So pre-Tidwell, the general rule was injuries sustained at home that are not covered by the workers' compensation system. On the other hand, injuries occurring at work are covered. Okay, so if it's an injury at home, it's not covered. If it's at work, it is covered. Pretty simple rule, right? Well, Tidwell and the cases pre-Tidwell that complicate things is, well, what if home is work? And what makes home the workplace, right? So the California Supreme Court has held that an employee who is injured while providing service and benefit sustains injury AOE-COE. What that means is no matter where you're working, if you are actually performing work, and you're injured, that will be compensable no matter where it happens, whether it's at a Starbucks, whether it's at an airport, whether it's at home. So that's the pre-Tidwell authority, which is service and benefit. Anytime you are actually performing work, that will be compensable no matter where you're located, okay? Tidwell was a little bit different because she was actually using the restroom, and we'll get into that. So one of the cases that I relied on when I defended Tidwell was a case called London Guarantee. And that was a California Supreme Court case from 1923. And in that case, an employee was injured at home, but it was not considered AOE-COE because he was not performing service to his employer. So in all these AOE-COEs, you're going to see the word service or benefit conferred, okay? So what happened in that case was an employee took some work home to be in a quieter place, arrived home at about 11 a.m., finished his work at around 12:30 p.m., had lunch, and was injured about a half an hour after lunch as he was approaching the door to return to work. In that case, the California Supreme Court said that the injury was not AOE-COE because the employee was not actually providing work-related service at the time of his injury. So I took that quote and I applied that to Tidwell, which was at the time of that she fell in her restroom, she was not actually providing service, although I knew the personal comfort doctrine was going to be an issue, right? So that was the approach that we took on Tidwell, among others. Continuing with pre-Tidwell cases, so here are some examples of injuries at home were considered compensable because service was being provided to the employer. A policeman who was injured cleaning his gun at home, pretty obvious, right? He needs his gun for work, he's cleaning it, there's some benefit conferred there, right? A policeman who was injured at home while training a police dog, again, training, okay, any type of training, any type of actual work, again, no matter where you're at, that's going to be compensable. An employee who was injured while cutting baseboards at home for a work project, again, you're providing actual service, you're doing actual work activities, always compensable. But then there was a case called Fox, an on-call physician who arose from her bed to investigate a noise, believing her phone was ringing. So she tried to make a connection to work, right? I'm on call, I heard my phone ringing, right? And went to check her phone. She was injured, and the court said, not AOE because it did not occur due to the reasonable use of the employer's premises. So all the attorneys in here know what that means. Employer premises means bunkhouse rule, right? Because she was sleeping. So that was kind of a bunkhouse case, but it gives you an idea of when home-based injuries are going to be compensable if it has to do with reasonable use of the employer's premises. So travel between work and home. Coming and going rule, also known as going and coming. Rich called it going and coming. I call it coming and going. Defense attorneys, if you're researching it, make sure you do both because you're going to get different sets of cases, okay? Trust me on that.
One's correct, one's not.
So actually, hands, how many defense attorneys here? I know that, Jake. Anybody else? Jake's the only defense attorney. Oh, shame on you, defense attorneys. All right, how many applicant attorneys here? Okay, and how many claims examiners? Okay, so I'd say about 50-50 between applicant attorneys and claims examiners. Okay, because sometimes that will impact the information that I get into. Some audiences don't care about certain things. It's not that I'm trying to not share, keep information secret or anything. Some people just don't care about certain things. So going and coming and going. Another case that we relied on that at least was cited in the Tidwell briefing was a case called Detente. So if the employer does not offer a workplace, then home becomes the workplace. And in my case, it was really important because my client, VTA, actually had a workplace that they wanted the claimant, I'll get into the facts, that they wanted the claimant to show up to. And instead, she wanted to work from home. And I'll get into the details behind it. Pretty interesting case. If the employee chooses to work from home, then the travel between home and work is not AOE-COE. This is the California Supreme Court case, Santa Rosa Junior College. I'm sure all the attorneys in here are familiar with that one. So that was also the primary authority that I was relying on because a quote from that case said, unless the employer requires the employee to labor at home as a condition of employment, the fact that an employee regularly works there does not transform the home into the second job site. So I'm thinking, okay, I've got some California Supreme Court authority on my side. I'm going to rely on this. I know that I've got this challenge with the personal comfort doctrine. The employer allowed her to work from home. So I'm trying to analyze all these different cases and all these different issues, okay? And one of the things that occurred to me is that as I'm researching all these cases, the cases I'm looking at, some of them are 100 years old. And so everyone in the room, earlier the Spanish flu case from Rich was talking about, I think it was 1918. Be careful when you're relying on cases that are 100 years old. The world is a really different place than it was 100 years ago, okay? So hands, how many people work sometimes somewhere other than the workplace, the fixed location? Is that almost everyone? Okay, about half. That's surprising. Okay, I actually thought almost every hand in the room was going to go up. So, these cases that have to do with injuries somewhere other than a fixed location before COVID, you've got to remember that the world is a completely different place now, and so do those cases even apply? Another case that I relied on was a case called Bramall, and that was similar to the Santa Rosa Junior College case. And in that one, it said for a home-based injury to be considered a work injury, the employer must have required the employee to work at home, and that was Bramall. And again, I'm taking all these quotes from all these different cases, and I'm trying to formulate my argument to show that in the case of Tidwell, she chose to work from home. She wasn't required to work from home, and therefore the home should not have been as expansive in terms of how and where an injury occurs to be considered a work-related injury. So after COVID, with modern technology, we've got more people working from home, and the thing that I was looking at as I'm analyzing Tidwell is, okay, we have more people working remotely. How much do these older cases really apply?
We ready?
Yeah, go ahead.
Okay. So let's get into the nitty-gritty of Deborah Tidwell's case. So Miss Tidwell comes into my office for a new meeting, and when I go out to greet her in the hallway in our meeting room, I see a woman who's in a motorized wheelchair. And being honest, that's pretty much every applicant's attorney's dream. But when I bring her to my office and we start talking, I quickly realize that she's not in a wheelchair because of a work injury. She actually has a pre-existing condition that's called Charcot-Marie-Tooth disease. And this is a disorder that attacks your peripheral nerves and basically causes severe or significant muscle weakness in the arms and the legs. And hers has deteriorated to the point where, as I noted, she's confined to a wheelchair basically 24/7, in a motorized wheelchair. And as a result of being in that wheelchair, obviously transferring to and from, when she has to use the restroom, transferring to and from her wheelchair to the toilet is always going to be an issue. And so she has a job where she works for the VTA in Santa Clara, and that's basically kind of a mini version of BART. And she's a data analyst, and what she does is she collects all their data that they show her on ridership, and then she basically creates reports that make sense of all that data, and so that the board of directors can do something with the ridership data. And she's working at the VTA actually in their fixed location, and as her condition's deteriorating, she's letting the employer know she's going to need special accommodations with her bathroom. And to the VTA's credit, they start making those accommodations, and they're putting up the necessary bars or whatever else she needs to make her transfer successful. And unfortunately, every time the VTA does something, for one reason or another, it doesn't meet her exact needs. And so there's this constant back and forth between the VTA and ADA director and my client over what's the proper bars and setup for the bathroom to be adequate. And while this back and forth is going on, she gets a note from her personal doctor saying it's probably best she works from home in the meantime for her own safety. And to the VTA's credit, they accommodate that and they allow her to work from home. And she does so for about 10 months. And one day she's working at her desk, and it's about 3 p.m. in the afternoon, and she has to use the restroom. So she goes from her home desk, she goes down the hallway to her bathroom, and as she's transferring from her wheelchair to the toilet, she falls and she breaks her leg. And she obviously has to be ambulanced out, has to spend some time in assisted living, and that's when she comes to see me because she gets a note in the mail that her claim has been denied. And when the case starts, the defendant denies the case and wants to argue 4 basic premises. Number 1, they argue that the employer did not require the applicant to work from home. Number 2, that the applicant's workspace is limited to her actual work area around her workstation. Number 3, the applicant was not providing work-related services at the time of her injury. This goes to the personal comfort doctrine. They're arguing she was using the restroom. And then number 4, the personal comfort doctrine has never been applied in a published decision where the alleged injury occurred at home. And their last argument was public policy dictates that an injury arising out of and in the course and scope of employment must not be extended to remote work locations. So the board, although all creative arguments, all were shot down.
At every level, by the way.
And one of the arguments, obviously the personal comfort doctrine was addressed by the judge, saying the personal comfort doctrine that applies to people at work in terms of having to use the restroom or go take a quick cigarette break, that's also going to be applied to people who are allowed to work from home. What the judge addressed was Jim had a concern, and he raised it in his trial brief, that by allowing somebody to work from home, that anytime they take a break, you're opening up a Pandora's box of injuries. There's so many things that could potentially happen while they take a break walking around their home that everything's going to be declared work-related. And the judge said they didn't agree with that logic, that any injury sustained in any area of Ms. Tidwell's home during her work week would not potentially be compensable. There may very well be areas of her home where an injury during her work week would not be compensable. just as there may be time during her work week where an injury in her home may not be compensable. And so what the judge was saying is it's going to be factually driven. And so that leads me to a question to Jim. If instead of let's assume Miss Tidwell, she wasn't confined to a wheelchair, she could actually walk. And she's working at her desk, and she has to use the restroom, and as she's walking to the bathroom, she trips over a laundry basket she left on the ground. Do you think that would be industrial? Does those facts change?
After Tidwell, yeah. After that decision, sure. So you know, the analysis going into Tidwell for us was, so how did we know that she had a dedicated workstation? We actually petitioned for an order to inspect her home, okay, to see what her home looked like. And, you know, for the employers out there allowing people to work at home, I strongly recommend that you, in some way or form, fashion, or whatever, make sure that you're working with your employees to make sure their place is safe if they're working from home, okay? You can do it by, you know, have them videotape their work area or whatever. That's toward the end of the presentation in terms of how to make work safe. So with a little bit of more information on Tidwell, the reason why we got into the situation, the employer, as Zach said, they'd begun construction on a restroom for Miss Tidwell. And my client is a public entity, so you know they probably had to go through requisitions and whatever. So there was horrible delay in getting things going and getting the construction started. And of course, you're going through a contractor, so you have a public entity with a contractor, so you have delay squared, right? So 10 months later, at a cost of about $100,000, they finish a restroom that I probably would have finished in my house in 2 weeks. And so they say, hey, you know, let's go, time to come back to work. And she shows up and she says, well, you know, my condition's progressive and I'm not sure that this is good enough anymore, okay? So you can imagine, you know, my client wasn't very happy about that, okay? You know, if before they finished the construction, if she'd gotten that doctor's report that said that her condition was progressive, what have you, you know, maybe we wouldn't have litigated it, okay? But that was a fact that really upset my client. And everyone here knows cases are all based on the facts, especially in workers' compensation, okay? I raised a public policy argument in Tidwell. Attorneys, don't waste your time, okay? Every case in work comp is about the facts of that particular case. The Workers' Compensation Appeals Board doesn't care about public policy. They don't care about the floodgates of litigation. They don't care about judicial economy. Those are things that I always used to talk about as a civil attorney, right? Well, Judge, you don't want the floodgate. Oh, no, I don't want a bunch of cases in my courtroom. You're right. Case dismissed, right? But in comp, those arguments really don't apply. I was trying to get as creative as I could. So going to your point, you know, I knew the personal comfort doctrine was going to be an issue for us. So my goal was to try as best as I could to put on a reasonable defense for my client as to why in this particular case, her work situation was so unique that it didn't extend to areas that it would otherwise if she were in the workplace. And if you're defending AOE-COE as a defense attorney, you know, it's really important that you are making reasonable arguments, and especially if you go to that Court of Appeal level, because if you're making arguments that aren't considered reasonable by the Court of Appeal, you're going to end up with, you're going to get hit with attorney's fees, right, for bringing a writ that is not reasonable. And if you get that finding from the Court of Appeal that says that your argument was not reasonable, what does that mean for all those benefits you delayed all the way up till that time, right? So it could be problematic. So in Tidwell, going in, I had a feeling we were going to lose. My goal was to come up with the most reasonable argument, the best good faith argument that I could as to why Ms. Tidwell's unique situation was different. And relying on all those cases, Bramall, Santa Rosa Junior College, all that talked about that the employer had to require her to work from home, that was my argument. And Tidwell was a legal argument. There was no factual dispute whatsoever. So for everyone out here who might not understand the difference, a legal dispute is he saw me fall at work. No, I didn't. Okay, that's a factual dispute, right? Factual dispute, he said, she said, right? Generally, I try to avoid going to trial on factual disputes. Why is that? One, you know, my witness is going to be pretty upset if the judge says you're a liar, right? Two, if you lose at that trial level and a credibility determination is made, it's really hard to overturn that on recon, okay? Three, if you go to a writ level, forget about it, because if it's a factual dispute, the findings of fact by the WCAB are binding. And there's the exception of if they're not substantial evidence. So I wanted to make this a legal argument, which we did. Zach and I basically stipulated to most of the facts. And we ended up making it a legal argument. By the way, Tidwell came out of Oakland. I tried to transfer venue to San Jose, and that was denied. They didn't want a woman in a wheelchair going to San Jose, I guess.
Who was your trial judge?
Who was the
Trial judge.
Judge Griffin.
Judge Griffin.
I want to go back to the hypothetical I gave you where you said if the facts were different and she could walk and she'd walked to the bathroom and tripped over her laundry basket, you thought it would still be industrial. And I want to give you some hope as a defense attorney that might not be true.
Okay. So if a condition of her home, I see what you're saying. So if there's a condition of her home that she's in control of because the employer didn't create the dangerous, I see what you're saying.
That's where I'm going with this.
Okay.
There's no California law on this, but there is a Florida workers' comp case that I think would give us a little guidance. And it involves a Sedgwick CMS claims manager. Shout out to the table in the back there. And she was working from home, and she decided to take a break from work to go to her kitchen to have a cup of coffee. And while she was in the kitchen reaching for her cup of coffee, she tripped over her dog and fell. And she filed a workers' comp claim saying, no, this was all work related. And the trial court in Florida said, yeah, we agree with you. And the defendant filed an appeal. And on appeal, the appellate court made an interesting argument. They looked at something you mentioned earlier. They looked at the AOE-COE argument. And they said, under COE, she meets the standard. Clearly, she was working. She was in the course and scope of her employment. But we don't think she meets the AOE standard, the arising out of employment. That by the act of tripping over her dog in her own kitchen while reaching for a cup was not a risk her employer introduced. And by not introducing that risk, they felt she didn't meet, her claim was basically denied.
And I think, too, what's important with that case is we're talking about a dog. That's something you normally don't have in the workplace, right? You don't have a bunch of dogs running around, right? There's not a bunch of pit bulls in most work locations. So that probably was a factor in the analysis as well. Now, something else sitting on the floor, whether it's a laundry basket or a box of paper or something like that, that could change the analysis, right? If it's a hazard that you would expect to see in the workplace, meaning the physical workplace. So if it's a unique hazard to home, in this situation a dog, another example would be, what if she had a boa constrictor that escaped and strangled her to death, right? Well, not a lot of boa constrictors in the workplace. So I think it is important to kind of analyze that. Is this a hazard that is reasonably expected to be in the workplace?
Going back to the Tidwell case real quick, you mentioned, you decided to videotape my client's home, her workstation and her bathroom. Why did you feel that was important? What was your strategy behind doing that?
So what I was trying to establish was the more that I could confine our exposure to a very specific area of the home, which was because she was disabled. So one of the facts that was in my favor was that she was disabled and had a dedicated workstation. Of course, one of the facts against me is she's in a wheelchair and she comes to trial in a wheelchair. Okay, those are pretty bad facts for any defense attorney, right? It made for a very sympathetic claimant. So what I was trying to do is I was trying to confine the work area to the most narrow possible area possible. And because she had a dedicated workstation, I argued that when she's at that dedicated workstation, she's working, clearly. But she said that any other time during the day where she goes anywhere else in her house, she can't work. She can only work at her dedicated workstation. So my argument was that little area is work. Everything else is home, no matter whether she's going to the restroom, whether she's making a sandwich, whether she's watching television, taking a nap. Again, I knew the challenges I was going to have with personal comfort, but that was my analysis. I was trying to confine work area to the smallest possible area within the home.
All right. So I think one area that hasn't been looked at yet that I think will eventually become a problem is people that work at home full time and then they're TTD and then they eventually get put on modified duty. and how to offer somebody modified duty who works at home. And so I have some interesting hypotheticals. I'd like to hear your answer, maybe Rich's as well. So you're an at-home worker, you have a 2-story home, and your home office is set up on the 2nd floor. And you're working one day, and you go from your home office to the bathroom up there, and you trip and fall and you break your leg. And the claim gets accepted, you go to the workers' comp doctor, and that doctor says, you can work, but your only work restriction is you can't go up and down stairs.
Okay.
And so the lady that works at home says, well, I can't go up and down my stairs. I've been on the 1st floor ever since my leg's been broken. I can't even make it up the stairs, so I can't work, so pay me TD. Does she do TD?
I think if work continues to be home, she's going to be entitled to TD because the work can't be accommodated. Now, in that situation, if the employer were to say, you know what, why don't you come in the office? And we have a nice, beautiful elevator for you that you can take up and down all day, right? We'll put you on the bottom floor. So the employer could the employer's ability to mitigate their risk on that, I think, is important. Now, if it's like a detente situation where the employee only works from home, the employer is probably going to lose that because the person has a restriction that doesn't prevent them from working, unless the employer wanted to do some type of modification to the home. And by the way, so we didn't rehearse these questions. He's ambushing me here, and I'm doing my best.
Do you think the employer could require her to move her home office downstairs?
I think if the employer were willing to pay for it and they were willing to do it promptly, and if the employer could establish we were ready to, if you're talking about a significant modification where she's got to knock out walls and completely change the fabric of her home, no. Definitely not. But if it's a simple modification and she refuses, then I think the employer would have an arguable defense.
You have any thoughts?
Yeah, anytime you make a medically appropriate modified or alternate offer to terminate TD, it has to be that. It has to be medically appropriate, modified or alternate. The degree to which the employer is willing to go to will really determine the issue. So if you make an offer, and the offer is, I will buy you new furniture, put downstairs, and knock out a wall. By the time that's done, hopefully she'll be PNS and the TD won't be owing. But if you say, come into the office now, and she's able to drive, or you're going to provide her with a driver, I think that's a reasonable accommodation. It's medically appropriate, and I think the TD ends.
Okay, so that you guys have kind of answered my second hypothetical. So you have a job where since COVID, your employer, you have an office location, but since COVID, so it's been about 2 or 3 years, you have worked at home full time. And you get injured at home, the defendant accepts the claim, and you go to the doctor, and the doctor issues a modified work note. And you can't offer that injured worker modified duty at home, but there is modified duty at the place of employment. And the injured worker says, no, I haven't been back there for 2 or 3 years, and why do I now have to do modified duty at the workplace?
You know where that could get complicated? It could depend on whether there's an unwritten rule regarding work at home or if there's a contract, if there's a written contract. Because that could possibly turn into a labor and employment issue as well, which is if the expectation was that if a term and condition of employment was that this person would only work from home, in that situation, maybe the employer would be on the hook for temporary disability. Now, if it was just kind of an informal thing, as long as there is reasonable work available and the employer extends it. Now, if it's unreasonable because, let's say the woman has to work from home for whatever, let's say she has, triplets that are all less than a year old, something like that. And that makes it very difficult, right? And you're asking her to change her personal circumstances, her ability to care for her young children. So in that situation, the employer might have problems. Now, if it's just simply a convenience, we would, you can work from home or you can work from the office. It's up to you. I think that's going to determine liability in that situation.
All right.
So with Tidwell, what was interesting was, as I indicated, I argued that simply because the employer allowed her to work from home, that didn't make home her workplace, right? That there was a physical location. She was requested to go there, and instead, due to her situation, her personal situation, very unique situation, she wanted to work from home. Now, there was a little bit of a shift from the old law cases where the simple allowance of the home-based work triggered liability. So that was in my opinion, a deviation from the old cases that all talked about if you require the employee to work from home. If you require them to work from home, then home is a workplace, right? So Tidwell was the first case that I'm aware of where the simple allowance of home-based work created liability. So moving on to travel between work and home. Okay, what are we talking about? We're talking about coming and going. And there's a case, Zoucha, Z-O-U-C-H-A, where the WCAB held that the mere transport of work materials to the job site did not make the commute AOE-COE. Instead, the WCAB focused on whether the employee needed his vehicle to travel to multiple job sites within the same day. That's the Hinojosa case. That's what's called the required vehicle exception, okay? So simply transporting materials wasn't enough. Now, post-COVID, and in light of again, Hinojosa is a 1972 case, we're talking 50 years, and we're post-COVID now, so different world, things are different. So if an employee is authorized to work from home and is injured traveling between home and the workplace during the workday, arguably that is travel between job sites. And in fact, that was the holding in a pre-COVID case, a workers' compensation case called New York Marine, where because the employee was allowed, and interestingly, that case was decided after Tidwell too, right? So Tidwell was the first one that talked about allowing people to work from home. A month later, this decision, the New York Marine General came out, and again, they said simply authorizing the work from home created additional liability for the employer in terms of, yes?
Go ahead. I was going to ask, do you mind if I talk about the facts of New York?
Oh, go ahead.
Case?
Absolutely.
So the New York General case is actually, the New York Marine and General case is actually a really interesting case. This gentleman worked for an animation company in Southern California, and through their clients, they had a bunch of international clients who worked in different time zones. And so the employer allowed this gentleman to spend, on certain days of the week, spend part of his time at the workplace, and then he would drive home and accommodate some of their clients who were in different time zones until he'd work from home. And so on one of those days, he is driving, he's at work, tells the employers he's going to go home to basically work some more. And on his commute home, he witnesses a road rage incident, excuse me. And he sees a truck driver and an SUV going back and forth at one another. And for whatever reason, the facts don't tell you, he decides to get involved. And he pulls up to the truck driver and in some way, shape, or form lets the truck driver know that he's the problem and not the SUV. Well, the truck driver didn't like that, and now the truck driver changes his attention to this applicant and starts following him. And this gentleman gets scared and actually pulls off the freeway. The truck driver follows him, gets out of his car, and actually stabs the guy in the back.
Oh, Jesus.
And so this guy who stabbed, he files a workers' comp claim. And so obviously the defendant immediately files a denial. And their denial is two things. One, the going and coming rule. And two, if there is an exception to the going and coming rule, this was a substantial deviation. And they first addressed the going and coming rule, saying, no, you as the employer allowed and actually acquiesced to him having a second workplace at his home. You knew he would leave work and go to home to continue working with your clients. So therefore, you created a dual workplace environment. So the commute from work to home, in this case, is going to be compensable. Now, as to the issue of when he got into the road rage incident and got stabbed, was that a substantial deviation? And unfortunately, there was a split panel decision. Two of the commissioners said no, and one of them, which was Judge Razzo, said no, that's probably a substantial deviation. But that was only one dissent, and it went up, and the board upheld it. So this is kind of what Rich warns about, of allowing people to work from home, some of this craziness that can happen.
Yeah, and interestingly, when you're talking about travel, the analysis shifts from service and benefit to deviation. Okay, any reasonable travel, you can stop at 7-Eleven, get a milkshake. You could whatever, maybe stop at a cigar bar. Okay, you go to a strip club, maybe not so much. But, what was interesting, because I read that decision as well, and Razzo, he's really the only, I think, reliable defense vote on the WCAB right now. Good for you, Jose. On that one, I think what the analysis was is it's not uncommon for people to maybe, you're planning on going from A to B, but somewhere along the way, you go to C. And, I thought the fact that he basically put himself in harm's way, I agree with Razzo on that one. I don't think that should have been compensable. I was a little surprised by that. And I think a lot of that had to do with the makeup of the panel, and I'll leave it at that. Okay.
It's always the judge's fault.
What was the rating on that broken leg case? How did the team
On Tidwell,
yeah,
actually funny, it ended up being a 7 WPI
Yeah.
for the broken leg?
for the broken
Yeah.
leg.
It ended up being a nothing case. So you're probably thinking, well, why did we fight it? She was in hospice care for like 2 years. So we got like a $500,000 bill, or it might have even been, maybe even in the millions, I forget. So there was significant exposure there. Because of her condition, she couldn't do physical therapy. And so she was in hospice for a really long time. So, if this were a simple slip and fall, she broke her femur, they expected her back to work in 8 weeks, would we have denied it? I don't know.
Do you want to talk about mitigation?
Now, I'm going to do remote locations.
Okay.
So London Guarantee, going back to that, remember that an injury sustained while actually working is always compensable. So there's a case called Willick, Willick, from 2002. That was an employee who was working at Starbucks, working remotely in 2002. Pretty interesting, because, we didn't really have great internet abilities back then, but was struck and killed by a vehicle at a Starbucks, and because was actually working, that was considered compensable. So remember, if you're actually working, no matter where you're at, that's always going to be compensable. Now, what I'm wondering is, so if you take the Willick decision and you take Hinjosa, which is the required vehicle, and what if you have an agreement with your employee where work from home means work from home? You only work from home. The employee says, you know what, I'm going to go to Starbucks, throws a laptop in the satchel, and the work agreement is work from home only, yet nonetheless this person decides that they're going to go to Starbucks and they're going to do some work there, and on the way there they get into a car accident and get killed. Is that going to be considered workers' compensation? Well, you are talking about, again, two workplaces. You're talking about home and Starbucks, which is going to be a workplace, because if you're killed at Starbucks while you're working there, it's considered the workplace. So, would it extend in that situation? So I think in that situation, the analysis might really come down to, what did the employer allow? Did the employer say remote work, meaning I don't care where you work as long as you're getting your work done, or was it work from home? So the contract between the employer and the employee might possibly impact that case, at least with respect to the travel. Now, even if the person isn't supposed to be working at Starbucks, and they go against their employer's wishes and they're working at Starbucks and they get killed, that's still going to be compensable based on the Williams case. So the Williams case says, where an employee is in the performance of the duties of his employer, the fact that the injury was sustained while performing the duty in an unauthorized manner or in violation of instructions or rules of his employer does not make the injury one incurred outside the scope of employment. Again, whenever you're performing work, that's always going to be compensable. We're talking about different travel in between different remote locations, and that gets a little bit more sticky. Do you have anything you want to throw in?
Keep going.
Okay. So, does the bunkhouse rule apply to home? And the defense attorneys, as I say that, they all shudder, right? What does that mean, the bunkhouse rule? So what is a bunkhouse? So the bunkhouse rule is whenever an employee lives or sleeps on the employer premises, any reasonable use of those premises is considered AOE-COE if injured while reasonably using the premises. So the bunkhouse rule, this comes from really, really old case law where you would have mining operations or something like that, and little cities would be created. And the people would work during the day, and because these mining towns or whatever it would be so distant, they wouldn't expect people to travel to and from work, so they would create little communities, and the people would live on the location. And so any reasonable use of that location, of those premises, would be considered injury AOE COE because you're on the employer's premises, and the contract of employment, there's an expectation that you're going to use those premises, right? So the reason this bunkhouse rule kind of piques my interest is I had a case, another Santa Clara VTA case called Capucci. So this is page 14 of the slide. Capucci was a case where my client VTA, they have sleep rooms on the premises and for their bus drivers. Now, those sleep rooms aren't intended to be living quarters. What they're really intended to be is, somebody who might have to pick up an extra shift because a bus driver calls in sick, or if there's a very short amount of time in between two shifts to go in there and kind of rest their eyes, rest their body. Well, in my situation, Capucci, due to the high cost of living in San Jose, she moved to Stockton. And what she would do 3 days a week, she would either use the sleep rooms, sleep at her sister's house, or she would sleep in her car on the VTA premises, okay? So Capucci was another case that I thought was really interesting because we all know the homelessness situation, the cost of living situation. So this was another case. It's like, okay, this is a really interesting case. And this has a chance to be a seminal case on the issue of, what do you do when you have these transient employees who are sleeping on the employer's premises in a trailer or in a car or something like that? Does that now create exposure for the employer because is this basically bunkhouse? So the facts of Capucci were a little sticky. On the night in question, she didn't know if she slept in her car for half the night and half the night in the sleep room, and unfortunately VTA didn't have a system to track who was using the sleep rooms. What I was looking for was some type of indication that she wasn't at all in the sleep room that day, that she didn't have a reservation, if you will, or whatever, but unfortunately those records didn't exist. Same thing with Tidwell. Going back to Tidwell, what I tried to do, I went through IT and I tried to get her login and log out information to figure out when was the last time she logged out. And if Tidwell had been logged out for 2 hours, I had a much stronger argument. Unfortunately, IT couldn't get me that information. So on Capucci, this was a woman who slept on the VTA premises, that we know. We don't know whether it was the sleep room or whether it was her car or a combination of the two. And VTA also has shower facilities. So she was sleeping, she woke up and she went and showered before her day of work, slipped, fell, hurt herself. And so I went to trial on that on AOE COE, okay? And again, my argument was that the entire VTA premises shouldn't be considered the work premises. And there was no requirement that she sleep on the facilities. This was all a result of her personal living situation being in Stockton, and she admitted that when she lived in San Jose, she never slept on the premises. There was no need for it, right? So again, I was trying to develop facts that were unique to her situation, to argue that her unique situation is what caused this injury, not VTA's need to have her actually sleep on the premises. So in that case, we went to trial, and the judge found that using the injury sustained while using the restroom was personal comfort, right? Which I had a feeling that was going to happen, and said, but you know what? Bunkhouse rule doesn't apply in this situation. Because of her unique circumstances and the employer didn't require that she sleep on the premises, bunkhouse doesn't apply. So I reconned. And the board came down and said, yeah, personal comfort, we agree. But you know what? It's also bunkhouse. So defense attorneys out there. And a lot of defense attorneys don't know this. When you seek recon, there's this common misperception that, the board can only review the specific issues raised. No. The board reviews its judge's decision. The board's judge, their powers and duties are delegated to them from the commissioners. So the commissioners can, once they grant review, they can grant review of everything. So you want to be very, very careful. If you have an otherwise favorable decision, but this TD rate of $10 more a week, we think we can win this, okay, be careful. Because the commissioners can look at that award in its totality, and you may get a decision different than you think you're going to get. So the board said, no, bunkhouse. So that was another one, took a writ on that, and the writ was denied on that one as well. And so in light of Capucci, my question is, knowing the bunkhouse rule, and now that home is work, so does the bunkhouse rule apply, meaning any injury sustained at home is considered a work-related injury? And it's pretty scary, right, when you think about that. So, my analysis on that is I don't think the board's going to go that far for a lot of different reasons. First off, it's not the employer's premises, right? The employer has no control over the premises. It's the employee's home. But more importantly, if it gets extended that far, and going back to public policy, which I know the board never likes to address, but you're going to really have a chilling effect of employers allowing people to work from home if any injury, any reasonable use of the person's own home, which we now know is the workplace, if that is covered by the bunkhouse rule, you're just going to create so much liability and so much exposure and uncertainty for employers. You're going to start to see a lot of people being asked to come back in the office. What that's going to create problems in terms of morale for employees. It's going to put more cars on the road. So even though I know the board never likes to address issues of public policy, I don't think the board would find the employee's home to apply to the bunkhouse rule.
First of all, I didn't know it was Capucci. It's actually cited on page 23 of your materials, Santa Clara Valley Transit Authorities versus WCAB. It was addressed last year, if you want my take on it. If I could just fill in just a couple of things, just a couple of comments here. First of all, when it comes to TD, to terminate temporary disability, I don't think the rules change. It's if you can make reasonable and medically appropriate accommodations to the injured worker, you're going to terminate TD if they refuse to accept that employment. Now, does that mean that you can bring them down to the office? I think potentially. Does that mean that you can make accommodations at their house? Potentially. As far as the bunkhouse rule, you have to understand that the bunkhouse rule is really predicated on benefit conferred to the employer. It generally is not going to apply to the home because they have to live someplace. There's no benefit. It's really benefit to the employee to be able to work from home often. So I don't think, and I think you're right, that they're probably not going to convert the house into the bunkhouse rule and make the liability flow from everything that might happen. My concern, and I'll just throw this out to both of you, and then we have to move on to the fun part of the conference, isn't the issue when the liability starts and ends? And I think that what you were doing in defending the Tidwell decision is correct. You want to go in there and you want to limit the scope of where the injury might occur and thereby avoid that liability by limiting the scope. Here's the desk, here's where she's working. Once she got up and left, all of a sudden she's on her own because we shouldn't be liable for that. Now, the personal comfort doctrine extends that liability. The other comment that I want to make is on the going and coming rule. The way that I analyze this is the going and coming rule, an exception is generally outside the scope. Okay, you're not going to have an employment relationship or liability from that. Special mission, though, is an exception to the going and coming rule, and substantial deviation is an exception to the special mission, which is an exception to the going and coming. That's the way that the analysis flows. They're not separate. So you have the going and coming outside the scope. Special mission, direction, control, benefit within the scope. Deviation from the special mission outside the scope because no longer you have control and you don't have benefit conferred. So that's kind of how the analysis goes in all the cases on that. But what do you think? Don't you think that it's all about the scope of potential liability?
Sure. And one of the things that, like I said, in Tidwell I had some good facts and I had some bad facts. The obvious terrible fact is it reasonable to assume that the employee will not use the restroom throughout the workday at home? I mean, of course, they're going to use the restroom, right? Going to get a drink of water, they're going to do that. So in that sense, I had a really bad case in terms of what the employee was doing. Now, if the employee had gone and made a sandwich and cut her finger, say severed her finger or something like that, or if she had burned herself badly on the stove, taking a break, the more that I could have deviated from, and Judge Griffin in this case basically said, look, public policy, I get all that, okay, but we're talking personal comfort. We're talking the most, I think he said, the most basic form of personal comfort.
Correct.
Right? Relieving yourself. I mean, like I said, it's not reasonable for an employer to think that you're not going to relieve yourself during the day, that you're not going to go and get a drink of water. So the more as the employer that you can distance the employee from things that they would do in the physical workplace, right? Like the dog. Okay, that's a pretty big deviation from what you'd expect in the physical workplace. The more that you can extend beyond what you would expect in the physical workplace, I think the better chance you have to defend the home-based injuries.
Okay. Well, we're going to take a 15-minute break, and they should be about ready to pour wine out there. We should all probably get a glass or two. And then these two gentlemen, so I'm not accused of having bias or otherwise, are going to actually pull the names out of the two separate bowls to find out who won what and why and if you deserve it, because we can take them back. Okay, let's take 15 minutes.
On behalf of the law offices of Richard L. Montalbo, we hope that you have enjoyed our presentation and thank you for viewing our conference. The Current Issues Workers' Compensation Conference is held annually on the third Friday of March each year. We look forward to seeing you later this year at our October Rating Conference and next year again at the 2024 Current Issues Workers' Compensation Conference.